All right. Okay. Thank you very much, everyone, for attending. My name is Helen Block. I'm a past president of the Decalogue Society of Lawyers. I'm very excited to introduce Gabrielle Mayoroni. I hope I'm pronouncing your name properly. Um, and before I get into specifically introducing you, Gabrielle, I want to mention that I see Howard Rosenberg is here, which I'm excited about because the reason why you are here today is because on June 24th, when the UNRWA lawsuit that your firm and your colleagues was filed, Howard emailed it to me and brought it to my attention. I saw you on JBS that night for an interview and was very excited to hear more about the case and learn more about the case and was thrilled that your firm had actually filed it. So I do want to thank Howard very much for bringing it to our attention, because if it weren't for Howard, you would probably not be here today. Also, I want to let you know that your colleague who signed the lawsuit along with you, Mr. Samet, his brother lives in Chicago, in the Chicago area. His brother's a doctor, and he's also very excited about this. And I had invited him to attend today, but I don't know if he was able to make it because of his duties at the hospital. But thank you very much. And I know he is also very excited that you and your firm and that his brother, Mr. Samet, is involved in this matter. So with that, let me get into your background. I understand that you are the founder of Law LLC, which is a law firm dedicated to advancing private human rights law by representing victims of international terrorism, crimes against humanity, and genocide in civil lawsuits to force accountability upon the financiers and aiders and abettors of the perpetrators of such crimes. You have created a counterterrorism research group to support the litigation that you and your firm does, and you conduct legal operational research on international money laundering, the finance of jihadi terrorist organizations in languages including Arabic, Farsi, English, French, German, Kurdish, Spanish, Italian, Portuguese, and Hebrew. You have over 35 years of legal experience, specializing in international taxation and business planning, and specializing over the last 2 decades in international human rights and humanitarian law, counterterrorism, transnational, and tort law. Mr. Mayoroni has served on the International Human Rights Committee of the American Bar Association, the subcommittees on humanitarian law and human rights and corporate responsibility. From 2012 through 2018, he volunteered as I don't even know how to pronounce this, so I'm just going to spell out the acronym, ECOSOC, delegate to the United Nations Human Rights Council. He's also a member of the American Association for Justice, the American Society of International Law, and the International Legal Team of the Kurdish Regional Government Group for the recognition of the Kurdish genocide in Washington, D.C. and London. So definitely wonderful things that you've been doing. The question in my mind is, how do you get paid so you're able to continue to do this wonderful work? And looking forward to hearing all about it. So thank you.
Okay, thanks so much for the nice introduction. So people normally call me Gavi. And the topic today, of course, is to introduce to other lawyers how we have built a team for representing victims or survivors of terrorism and other international crimes, such as weaponization of mass rape in civil litigation against the financial networks that either support or profit from these crimes. Slide the door, please. So my purpose is that, first of all, the topic is really broad, and it's almost like a semester of law school to teach all this. So what I wanted to do is I do a very comprehensive PowerPoint presentation, which I'm not going to have time to go through, but we're providing it to the Decalogue, so that society, so that everyone can get copies of it, and you'll be able to find, delve in deeper into the topics I'm going to discuss. So when we started Law, the idea was that we were going to represent clients just on a success basis, contingency fee, which is typical in America, but atypical in the rest of the world. And we're a law firm that doesn't really function within national borders. We're more global in our approach. and to find the money trail and map the terrorist organizations, develop admissible evidence linking the financiers to the terrorists, enter into strategic partners with top-tier mass tort law firms, since that is really not what our expertise has been in. Our expertise is in representing the clients and in doing the research, and initiate then litigation against the financiers and those who provide financial or other material support to the networks. So as General Petraeus said, it takes a network to defeat a network. And the terrorists are organized into all kinds of networks, including support and financial network. And not everything can be handled by military force or police forces or intelligence organizations. And certainly when we're talking about criminal prosecutions beyond reasonable doubt, a lot of the perpetrators or participants in these networks can escape justice. On the other hand, as we're victim-centered, so then for instance, killing bin Laden may have gotten some satisfaction for those victims and the families of the victims of 9/11 as an example. But for many of the cases, in fact, we represent over 19,000 victims now worldwide, most of which are really indigent and poor. And so punishing the perpetrators doesn't really bring justice to the victims. What they need is they need compensation. Okay, next slide. So to understand everything, it's essential to understand Arabic and Farsi. The first case that we did was actually litigated in Chicago. It was Boehm versus the Holy Land Foundation, and the lawyers there, Steve Landis is an old friend, and he was the chief lawyer there, and they took it on a pro bono case to file a lawsuit against the largest Muslim charity at the time, which was actually a front for Hamas. But they didn't have any, and because they did it pro bono, they didn't have a lot of resources to go ahead and spend a lot of money developing that case. The FBI, after the civil case was filed, the FBI went ahead and raided the Holy Land Foundation's offices in Texas. They also had offices in Bridgeview, outside of Chicago. And they seized 20,000 documents in Arabic, of which the lawyers had no idea how to read those, nor did they have the expenses for this pro bono case to go ahead and translate all this to see what would be relevant. And as you can imagine, most of it wouldn't have been relevant anyway. And that's just when we were starting up back in 2001. And so I brought some of our Arabic speaking experts to Chicago. And we sat down and we went through all of the documents to be able to select what was relevant. The one piece of evidence that was missing was actually connecting the actual perpetrator who killed David to Hamas itself. And with our research team and going through Israeli archives and so on, and this was pre-internet claims of responsibility, we were able to locate a flyer in which Hamas took responsibility for the murder. And without that, the case wouldn't have been successful. The case was successful. And then afterwards, there was criminal prosecution of all the boards of directors who today are all in prison in the United States. So going back to understanding, Sheikh Yusuf Qadawi, who passed away a couple of years ago, was the leading cleric for the Muslim Brotherhood and of Hamas. And here's just something that we downloaded, which we introduced as evidence, which he talks about jihad by money, or we call it financial jihad. And what Sheikh Qardawi explains is under Sharia law that everyone has an obligation to participate in jihad. And this is something this was not classical Islam, but this was his religious edict, his fatwa, which is adopted by all the global jihad terrorists and terrorist organizations, that every single Muslim has an obligation to do jihad. But jihad can either be done by the soul or by money. And in fact, Sheikh Qardawi said by money is more important. What does by money mean? By soul is the mujahideen who are going to go and do a suicide bombing or do a terrorist attack and risk their lives. But they need the money behind them to be able to support their families when they're off fighting, or if something happens to them, take care of their families when they're gone. and of course provide medical services and everything else, and of course the money for weaponry and everything else. And so what Sheikh Qadawi said is, according to the Quran, jihad by money is actually a higher religious a goal or a religious precept than actually fighting a jihad by soul. And this is a quote which we downloaded from his website. You can see it in Arabic, and then the translation. Next slide. So we're going to rush through these slides so that we can get through all of them and leave plenty of time for questions. But you'll all have these slides, and if any later on anyone wants to ask us questions about or something, will be available. So here there's just a quote from back in the day, back in 2008, from the Treasury Department in testimony before Senate, which shows the extent and importance of laundering money for terrorism in very different ways. Next slide. There's another quote similar to the thing, that Iran also funds hundreds of millions of dollars through the year, and designating Iran's Bank Melli, Bank Mellet, and Ben Saderat, all of three banks we have sued and we have judgments against for various attacks that were sponsored through those banks. Next slide. So this is a snapshot of the Iranian-based network of terrorist organizations. The thing I want to, and you can all take your time later on in looking at it, but what I want to emphasize two things. On the top, you see it's the Ayatollah. The Ayatollah is not part of the Iranian government. He's a cleric above the government, okay? They call it the righteous jurist. And he can veto everything, anything, and he can direct the government to go in certain things. He's kind of like an advisor, but with complete power. So, okay, above him, you have in the center, you have the government itself, headed by the president and all the ministries that you would accept, and many other ministries that you would expect in a normal government. On the two sides, it's really one organization, IRGC, but just the Islamic Revolutionary Guard Corps, which several years ago was designated as a foreign terrorist organization by the United States. And actually, I was consulted on that with the legal counsel for the Senate Judiciary Committee, and there was many people pushing for that, and I also lent a hand. So, and here I'm going to break the IRGC into two different sides just for understanding what it is. Okay, so if you look on face the left side of the screen, you see IRGC, and then underneath bunyads or foundations. Okay, and then two giant ones, bunyad or foundation, the Shahid Foundation and the Alavi Foundation. Okay, these are gigantic so-called charitable organizations that control now around 50% of the economy of Iran. They've grown much, much more powerful during all the sanctions, because with the strict sanctions the United States placed on Iran over the years have caused so many businesses in Iran to go out of business, from being unable to import goods to sell goods internationally and so on. But the organizations that were run by the criminal kind of organization, the IRGC, they survived, and they scooped up and bought all kinds of things: oil wells, hotels, industry, construction, all kinds of industries. On the right side of the screen, you have the terrorist side of IRGC, and it's broken up into two forces: the Al-Quds force and the Basij. The Basij is a huge force, maybe as many as hundreds and hundreds of thousands of members, mostly peasants from all across the country, and their job is to suppress any kind of social unrest or protest against the regime and against the Ayatollah. The second is Al-Quds force, is what's called the force to export the revolution. Okay, and that is the part of the IRGC which does all the international terrorism, supporting Hezbollah and others. Under the prior Trump presidency, the United States assassinated Qasem Soleimani, who was the head of the Quds force, an incredibly powerful and charismatic leader for many years. And he developed a strategy called the Ring of Fire strategy. The Ring of Fire is to surround Israel with all in every direction with terrorists who, when Iran needed it, would launch coordinated attacks against Israel from every direction to overwhelm them. What happened on October 7th is that Yahya Sinwar launched the attack without coordinating it with all the other members. And so that caused, lucky for Israel, because then Hezbollah didn't launch on the 7th a similar attack, which would have overwhelmed Israeli forces in the north. But that was the goal. After the 7th, then one by one, everyone joined. So you see there Hamas, you see Hezbollah. PIG is Palestinian Islamic Jihad. That's a Palestinian organization that's totally controlled by Iran. The Houthis from Taiman. And you see to the far left, Hashr al-Shabi. There's 67 groups actually in Iraq that are Iranian-controlled terrorist organizations. The most important ones I've listed in the box. Next slide. Now, so on the one hand, we've got the Shia terrorist network, which is run by and influenced by and supported by Iran principally. On the other hand, we have the global jihad network, which is Sunni Arab. It comes out of originally from Saudi Arabia, from Wahhabi kind of very radical Islam that is now being sort of purged in Saudi Arabia, but for 100 years was there. Together with what's called the Deobandi Pakistan Alliance, which is Afghanistan, Pakistan. And this was a kind of Islam that was developed to resist British occupation of India, Pakistan in the day, and has since then evolved into what we call today now the Taliban and Haqqani Network and so on, is very radical global jihad, viewing the West and the United States as the principal enemies. Okay. You see in the middle Maktab al-Qinawi, which is really services office, was formed by Abdullah Zaman bin Laden, which became Al-Qaeda, and Zawahiri, who is the head of the Egyptian Islamic Jihad, who was imprisoned and then released for the assassination of President Sadat. When he joined Abdullah Zaman bin Laden, that's how Al-Qaeda was born. And under here, you see the various organizations that were created by Al-Qaeda. And you can see to the far left, Hamas, which is was originally part of the Muslim Brotherhood, still is. But you see under Al-Qaeda, they formed Al-Qaeda in Iraq. That was when American troops were in Iraq and fighting. The head of that was killed, and his successor was killed by the Americans. And then when the Syrian civil war erupted, they exported their remaining soldiers and so on and leaders to Syria, and they formed ISIL. And ISIL still today, even though it's been defeated again in Iraq and Syria, is still powerful and launches attacks around the world, as do all of these Al-Qaeda and all of these Taliban-type organizations are still, after 20 years of warfare against them, are still functioning and still dangerous. Next slide. So how do we prove the cases? So here, just as an example, okay, so on the right-hand side, you'll see a claim of responsibility for an attack that was launched on French Hill in Jerusalem, okay, in March 2001. And to the left, you see that we obtained somehow, actually from captured documents, a list of wire transfers that was done through the Arab Bank. And we sued the Arab Bank for supporting terrorism. And here, it's not only a matter of understanding Arabic, but it's understanding the Palestinian society, the rules of how people's names are, where their clans are, how to identify them. And through our research, we were able to identify the mother of the suicide bomber, who on the right-hand side was listed by Hamas as a martyr. And we were able to identify his mother's name, and then we found the wire transfer made to the mother that was processed by Arab Bank, supporting her after her son committed suicide and killed people in that attack. Next slide. Here's another similar example. Again, a claim of responsibility that we were able to find. This is an attack on Rehov Ben Yehuda in Jerusalem. Many of you probably know it. It killed 11 and wounded 170. This is Hamas's claim of responsibility for that attack. Next page. And through captured documents by the Israeli army, we were able to get copies of checks that were cut to the widow of the suicide bomber, one of the suicide bombers, and the father of one. And so each drawn in the Palestinian Islamic Bank. These checks, though, the money for this account came from Saddam Hussein. And so we brought in a second lawsuit against oil companies that were paying kickbacks to Saddam Hussein in violation of sanctions. And those funds were being used because there were sanctions on Iraq after the first Gulf War to prevent Iraq from having any cash in US dollars to be able to support terrorism. And so the kickbacks were paid by American oil companies and European oil companies, Russian, and we sued in the United States some American oil companies, and we settled the case. And this was part of the evidence of the case. Next slide. So what's the legal regime to bring these kinds of lawsuits? So there's three principal statutes in America that we use. The first one we're going to talk about is the Anti-Terrorism Act. We call it ATA. And here I've quoted the relevant provisions of it. And that provides under Section 2333, a civil remedy. The Anti-Terrorism Act itself is essentially a criminal statute with many, many, many sections. And basically what it does is empowers the United States to prosecute crimes of terrorism committed against American citizens outside of the United States, extraterritorial, which is unusual. Normally, your jurisdiction for prosecuting crimes is only within your territory. Okay, so, but in addition to the criminal side, Congress attached a civil side, giving to the survivors or the victims of terrorist attacks, American victims, to be able to bring civil lawsuits against anyone who was connected to the attack. The original language in 2333 did not mention aiding and abetting specifically. It just said you could bring claims. Courts have held that the words "by reason of" means that it's proximate cause. You don't need to have but-for causation, but it does not include secondary liability. Let me go back. It does not include secondary liability unless Congress specifies therefore. So for 7 years, numerous we and others, and especially the 9/11 clients, were pressing Congress to amend the law to specifically provide secondary liability, meaning aiding and abetting, which resulted in 233D, which you see below. And here what it's talking about is that there will be second liability, but only in the limited case sense where it's a designated foreign terrorist organization that committed, planned, or authorized the attack. And therefore, any person who aids and abets that by providing, again, substantial assistance, knowingly substantial assistance, these are key words, or conspires with the person who committed such an act of international terrorism. So what's a foreign terrorist organization? So the United States now used to have three, now has two designations for terrorists. One is called a specially designated global terrorist. That's the most common one. That's by executive order. And there's a list that is maintained by OFAC that any people on that list, there can't be any, and no Americans allowed to do business with them or transfer money to them and so on. And there's software that banks use to make sure that to screen any wire transfers to anyone on that list. The second list is called Foreign Terrorist Organization. It's much more extensive and on terms of the restrictions on doing any business with them, and that's designated normally by Secretary of State. Okay, there's many legal consequences. One of the legal consequences of foreign terrorist organization, for instance, is the World Bank, and no bank worldwide can do any business with such an organization. They have to freeze the accounts. So this is what was called the JASTA. We're going to go look at this a little bit later in a couple of slides. The courts have interpreted this in the most restrictive of all ways, which has pretty much put all the lawsuits that have been filed since this amendment was enacted into danger of being they're dismissed and we're up on appeal and so on. So we're before Congress again to expand this definition. But right now, this is the definition for aiding and abetting liability under ATA. Next slide. So first of all, we said it has to be an American who has been victimized of an act of international terrorism. So what is international terrorism? So it's a violent act that's dangerous to human life, okay? And it appears to be intended to intimidate or coerce or influence the policy or affect the conduct of a government by mass destruction, assassination, or kidnapping. And it occurs primarily outside the territorial jurisdiction of the United States or transcends national bodies and so on. So that's international and it's terrorism. It does not cover domestic terrorism. Domestic terrorism could be something, you know, like the Oklahoma City bombing or something when it was an attack on the FBI's offices or something. So the ATA only deals with international terrorism. And first you have to see if you have an act of international terrorism itself to start the applicability of this statute. Next. So then one of the requirements in asserting liability is that the act of international terrorism had to be a criminal act under U.S. or state law, or would be a criminal act under U.S. or state law had it occurred in the United States. So the statute itself provides a couple of examples of what kind of criminal acts would be a predicate for asserting jurisdiction under the ATA. And I'm going to show you three of them here, which are also relevant to us. So this is talking about providing material support or resources, or conceals the nature of such a thing. Okay, that they are used in preparation for or carrying a violation of sections blah 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 blah, which are violent acts of terrorism. Okay, so this is one of the that when we file a complaint and we allege that we're suing for aiding and abetting an act of terrorism, we have to show there's an act of terrorism, and we have to show there's a violation of criminal law as part of that definition. Here, there's a very helpful definition also in B of what does it mean material support or resources, and you can see it's extremely extensive, which is and later on we're going to show you a little bit on a case study of how we filed the case against UNRWA, and you'll see that we actually lift some of these exact instances of what is material support. Okay, next slide. Okay, then this is 2339B, the second example, and this is a very good example for us, especially under now aiding and abetting or conspiracy. We have to show that there's a FTO, foreign terrorist organization, involved. And here Congress is very specific that whoever knowingly provides material support or resources to a foreign terrorist organization, which I told you what that is, or even attempts or conspires to do so, she'll go to jail for 15 years and so on. So that's the criminal act that's a predicate for asserting civil liability. And to violate this paragraph, the person must have knowledge that the organization is designated FTO, okay, that it engages in terror activity, or that it has engaged in terrorism. So this is very important for scienter, that we don't have to show intent. We have to show that the aider and abetter had the knowledge that they were either dealing with an FTO or that this was an organization that was engaged in terrorism. So there has to be some kind of knowledge, but not intent. Next slide. Okay, and here's another, the third statute I want to say, 2339C. And here you can see, again, this is prohibitions against the financing of terrorism. And so whoever is described in B above, by any means, directly or indirectly, unlawfully and willfully, provides or collects funds with the intention that they be used or with the knowledge that they could be used to, and et cetera, down the statute. So again, as I said, you'll have all these slides. You can take your time and understand them a little better, but I'm just trying to give you an overview. Okay, next slide. So remember, I told you that we got an amendment to the Anti-Terrorism Act after many years in 2018. And I showed you that the amendment specifically provided aiding and abetting and conspiracy liability. What this slide I wanted to present is that within that act, the Justice Against Sponsors of Terrorism Act, which we call JASTA, J-A-S-T-A, that this act, the findings and the purpose are important. So the findings, of course, is that if you look in 3, of course, it's just recognizing that there's affiliate groups that are participating in terrorism attacks. Okay. And that it's necessary to recognize the subset of causes, but most important, persons. C. Persons are countries. So that could be even countries like Saudi Arabia or Iran that knowingly or recklessly contribute material support or resources directly or indirectly. Very important. Directly or indirectly to persons or organizations that pose a significant risk of committing acts of terrorism that threaten the United States, policy, persons, etc. Okay. Necessary to direct their conduct at the United States and should reasonably anticipate being brought to court in the United States. So everyone can see here, this is trying to satisfy, Congress is saying that anyone who does this is sufficient contacts within the United States, even they're located abroad, to meet under the constitutional protections for due process and so on, and being held accountable in the United States courts. So this is Congress trying to instruct the courts that we mustered under the Constitution. Pay attention to the words directly or indirectly. Okay, I'm going to speak about that in a second. So the last thing here is the purpose of this act is to provide civil litigants with the broadest possible basis consistent with the Constitution to seek relief against persons, entities, foreign countries, wherever acting or wherever they may be found, that are providing material support directly or indirectly to foreign organizations or persons that engage in terrorist activities against the United States. It didn't say foreign terrorist organizations. So it's very broad. So Congress is saying that its intention is to give civil litigants the broadest possible use of aiding and abetting or financing terrorism that has been directed at the United States or has United States persons or the United States itself who are victims. And it can be done directly or indirectly. Now, what the courts have done with this is they've quoted this all the time. And it says very nice that Congress told us what their intention was, but when they looked at the statute itself, they don't see the words directly or indirectly. Okay, can we go back a couple slides to where we had the go back to 233, another one, 2 more slides back. 1 more. Okay. I guess 1 more than that. 1 more back. Okay, liability. So what the courts have focused on, liability in action for an injury arising out of act in relation to terrorism committed, planned, or authorized by an organization that's an FTO. As of the date, it was an FTO as of the date it committed, planned, or authorized. Liability means to any person who aids and abets by knowing or providing substantial assistance or conspires. And the courts have said, wait a minute, it doesn't say here directly or indirectly. So thank you very much, Congress, for telling me what your intention was. But as far as the courts have said, and then one after another, the courts have all been following it, we think that you missed the mark. Now, how does this affect us? So we have a case pending against 8 of the largest European banks, okay, such as HSBC, Standard Chartered, Deutsche Bank, Credit Suisse, Credit Lyonnais, Barclays Bank, Commerzbank, okay? We are representing around 3,000 Gold Star families and vets, and we've sued these banks for the terrorist attacks that occurred in Iraq during 2003 to 2011. And because they admitted in deferral prosecution agreements that they laundered $900 billion plus to Iran in violation of the sanctions. And we said the sanctions that they knew that they were violating, and even in their internal emails that we found in the deferral prosecution statement of facts, they knew that the purpose of the sanctions was to keep Iran from having a hard cash to be able to use as terrorism. We also, and I didn't include a slide on this, and I guess I should have. We had also got passed through Congress by unanimous consent in both houses an act which we call the Anti-Terrorism Clarification Act. That act, it clarified something called the act of war. Okay, if you go back to the definition of international terrorism, you'll see that it's a violent or acts that are dangerous to human life that appear to be intended to intimidate or coerce a government or influence their policy. So think about that for a second. Every single soldier in every war, that's exactly what the army is trying to do. It's using violence to try to intimidate the government, who's our enemy or our adversary, to surrender, to change their policy, to withdraw from, for instance, we may be using, let's say Ukraine is using against Russia, its army, to get the Russians to leave their country. So that would fit the definition of international terrorism, right? And so there's a second provision in the ATA that says any act of war is not considered an act of international terrorism. So there's a carve out. And then it goes on to define what's an act of war. And there's three components. One is a declared war between countries. The second is a war that's not declared, but it's between countries. And the third says military force of any origin. So military force of any origin, and not another country's army, and not in a declared war. What is that? And so there was a case brought by some American victims by other lawyers from 2006, when there was a war against Hezbollah. There was a battle between Hezbollah and Israel. And Hezbollah at that time also rained rockets and missiles on Israeli cities and killed a number of Americans. And though the survivors from those brought the lawsuit, the court held that it's not terrorism. Shooting all these rockets into Israeli cities was not terrorism. It's an act of war. And the lawyers who brought that case did not do some significant research, were not well prepared, and created a horrible precedent for us all. So when we wanted to bring the case on behalf of the American soldiers that were killed or injured in Iraq, then we wanted to clarify that they were killed not in war, they were killed by terrorists in terrorist thing. And in fact, although America first inserted into Iraq to defeat Saddam's army, but after 6 or 8 months, whatever it was, 7 months, the United States then turned over the prosecution of everything else that happened in Iraq for the next 8 years to the United Nations, which established a peacekeeping force, actually, technically, made up of a coalition, of course, which the United States was sort of in charge of. So I went to Congress and I drafted the language that said, carve out to the carve out. There's a good tax lawyer. We have all these things always going on. And so the carve out is the act of war, and then it is not terrorism. And then any action by a designated terrorist organization is never an act of war, is never a military force of any origin, because they don't abide by the Geneva Convention and the laws of war. Therefore, when Congress said a military force, it obviously did not mean terrorists, okay? And we got it passed 100% in both houses, signed by the president, and that's part of the ATA. So that's why we're able to bring the case against all these banks that were financing Iran. But as I explained, then all those cases are being dismissed and they're all stacked up for appeal in the Second Circuit. And at this time, we're trying to push through in Congress an amendment which then will clarify this direct and indirect as part of the statute, and also expand that we're not talking just about foreign terrorist organizations. We're talking about specially designated global terrorists and any terrorist organization supported by state-sponsored terrorism. So you might see the charts that I provide up front. That's an example of all the different kinds of terrorist organizations. We have brought lawsuits also victims of the Taliban, Haqqani Network, and others in Afghanistan. Let's go back, continue on now back to where we were. Keep, you're going the wrong direction. Keep going. Next, okay. Second law that we're interested in is called the Alien Torts Claims Act. So the Supreme Court calls it the Alien Torts Statute, ATS, ATA, ATS. The entire statute is right there on the screen. The district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the laws of nations or treaty of the United States. This was passed in 1789. An example of how the revolution that created the United States and our Constitution was idealistic about, creating a new kind of thing, a democracy that created the rule of law, and that it was an example, it was for the whole world. So Congress, in the first Congress, said is that an alien, not Americans. Americans, we have American law. So if American has a claim of being injured by anybody, there's either state law or in some cases federal law. But the question is, what about people who are not in America? And the only laws of nations or international law in 1789, there was just a couple. One was piracy, protecting diplomats. The second was outlawing piracy and the obligation of all countries not to give safe harbor to pirates. And then there were some beginnings of international laws of warfare, that soldiers had to identify themselves, that there was protected persons, and it was lawful to kill an enemy soldier, but not civilians or an enemy soldier who has left the battlefield or is injured. Okay, those were the whole laws of nations. The Supreme Court in 2004 ruled that when they said this says the laws of nations, it doesn't mean international law at the time of 1789. It means what it is today, which would include genocide, crimes against humanity, and everything. So, pay attention here. This statute is only for aliens that can bring this case in the United States. We brought our case against the Arab Bank on behalf of our American clients, in which we, after a jury trial, we prevailed, and then we settled with the Arab Bank. But on the non-American clients that were in that case, and there was thousands of them, we brought under this case. But at some point after the Supreme Court was after Trump appointed a number of judges in the Supreme Court, the Supreme Court ruled against us and threw the case, dismissed the case on subject matter jurisdiction grounds, that what Congress intended is not that anywhere in the world a violation of laws of nations. There had to be a substantial connection to the United States, the territory of the United States of America somehow. How they came up with that definition is difficult to understand, but there's virtually no jurisprudence on this statute, almost no jurisprudence, until we brought the case on this statute and tried it out. So that was that. Unfortunately, that was this. We're still litigating now that case in Israel on behalf of the Israeli clients. I'm going to get back to this statute in a couple of minutes. Next one. No, go back two because we skipped one. There should be, there you go. Okay. The third statute that we work with is the Foreign Sovereign Immunity Act. So what's that? So sovereigns all have immunity and under international law, and every country gives immunity to every other country. And there's a reason why every country does it, which makes it part of international law, is that each country doesn't want its diplomats or persons itself being tried by other countries. Okay. So in the 1950s, I guess, there is 60, maybe 1960s and 70s, there was a problem in the United States with principally with the Soviet Union that would contract for agricultural things or other kinds of things, and then take delivery and then breach the contract. Okay, maybe they put up letters of credit from the central bank, whatever it's called in Moscow in those days, and then they would refuse to honor the letter of credit after the product got delivered. And so case by case by case, there were so many cases suing the Soviet Union for breach of contract. Okay, and each time, so you say, hey, we got immunity. And the judges were unsure how to deal with it. So they would request the State Department to, if they're to provide a statement of interest. And the State Department would say, yes, they have immunity in this case. No, they don't have immunity in this case. And over time, there was no consistency and as administrations changed, the State Department's views could have changed. Okay. But worse than that, it was a violation of separation of powers because the judges were saying, hey, we're supposed to determine and judge what are the facts and what are the law. And yet here we've transferred that to the executive branch to tell us, is there immunity or non-immunity? So Congress responded by passing this law. This law, and this is just one section of it, which is relevant for us, but this law says that there's three times where immunity is stripped. One, for torts committed within the United States by a foreign sovereign for civil damages only, not criminal. Two, for commercial contracts. That solved the problem of the Soviet Union. And three, for designated state sponsors of terrorism. Okay. Now, who can bring a lawsuit in this statute? Only United States citizens. The same as under the ATA. Only United States citizens can bring cases under the ATA. Okay, except that we expanded the jurisdiction here, and you're going to see it in this thing. So, in 1976, when this statute was written, there was not a definition of what is international terrorism or terrorism that was accepted worldwide because of all kinds of problems in the United Nations and so on. So what they did was they created, instead of an act of international terrorism, that it has to arise from predicate acts, which were considered terrorist acts at that time: torture, extrajudicial killing, aircraft sabotage, or hostage taking, like all the hostages were taken in Lebanon in the 70s and 80s. Okay, aircraft sabotage, bombs were put on planes. Okay, so this says that we can sue any designated state sponsor of terrorism. Who are they? Today, it's Iran, Syria, North Korea, and Cuba. In the past, it included Libya, Iraq, Syria. Syria is also today. Okay, so but it never included Saudi Arabia. It didn't include Sudan. Doesn't include Pakistan. Obviously, they support terrorism and have support terrorism, but they were not designated. So American citizens who are killed or injured by an act of terrorism, we can bring a case, and we have brought cases, and we have billions of dollars in judgments against Iran, against Sudan, against Syria, etc. And in fact, in the case of Sudan, we actually settled those claims with our victims, our clients who had judgments on Sudan. That's a whole other story. So, but the problem here is that it's only American citizens, okay, that can bring this case. And where is that a problem? Because in the 1983 bombing of the Marines barracks in Lebanon, one of the Marines who was killed happened to be a kid who, an 18-year-old whose family immigrated to the United States, Texas legally when he was 16. He finished high school and he enlisted in the Marines. And as part of his service, he was killed in the Hezbollah attack on the Marine barrack in Lebanon when they were trying to as a peacekeeping force. And so his claim, out of all the other Marines killed there, he didn't have a claim because he wasn't an American citizen, because he moved here when he was 16. He was then 18 when he died, or 19. And if you know immigration law, you have to have a green card for 5 years before you can apply for citizenship. So he had not yet had a chance to even apply for citizenship. So using that case and some other kinds of problems that we had, okay, you'll see that we added the bottom, okay, which is that it's not just a national of the United States. That's in the bottom sub paragraphs. Okay, the claimant, the victim at the time occurred was one, a national of the United States. So that was the original law. And then we expanded a member of the armed forces, or otherwise an employee of the government of the United States, or a contractor, an individual performing a contract by the United States, acting within the scope of the employer's the employee's employment. So this gate opened the door for us to represent the victims of the U.S. Embassy bombings in Nairobi and Dar es Salaam in 1998. This amendment was signed by President George W. Bush in January of 2008, and August would have been our 10-year statute of limitations, and we rushed and we filed lawsuits on behalf of hundreds and hundreds, not only of Americans from the U.S. Embassy bombing, but on employees that were working in the embassy that were either Kenyans or Tanzanians and their related family members. And we ended up with an $8 billion judgment on their behalf. And as I said, against Sudan and Iran, and we collected again several hundreds of millions of dollars on Sudan in a settlement. Okay, and here we were able to have the employees. Just note that an employee of the United States government has standing to bring this case, no matter if he's working at the time or not at the time, but as long as they're an employee of the United States government. A contractor of the United States government can bring this case only if the injury occurred while they were performing their contract. For instance, a security guard or someone as an electrician working in the embassy at the time of the blast, then they would, and we have many clients like that. Okay, next slide. So we talked about ATS. Okay, so now this is our claim. We represent today about 1,400 victims from the October 7th attack in Israel. Okay, yeah, just getting questions. Yes, we've collected already $1.8 billion in judgments. Someone asked if we've collected. We have many, many more billions, and we're working on it, and we've got cases pending on collection actions. So, so the idea was to try to bring a lawsuit against UNRWA and the director general and deputy, and then the two priors of that and the head of finance there. And that was because we were following all kinds of research and facts, and we saw the overwhelming presence of UNRWA hand in glove with Hamas in Gaza. And so the question then was, do we bring a case under the Anti-Terrorism Act, and we have our American clients, and we have about 200, or do we bring a case under the Alien Tort Statute by our non-American clients? And strategically, we chose to bring the case, first of all, by the non-Americans, and we're in the process now of filing a second case on behalf of the Americans under the ATA. And the reason is because of the issue of immunity. That my idea was that it cannot be that a United Nations body has immunity for committing genocide. Okay, the United States, if it has a counterterrorism law, it can give immunity for that law, just like it could for murder or for any other American crime. But I figured that under what we call use Kogan violations, are violations that are non-derogatory under any circumstances, and they include only those kinds of crimes or violations which all of humanity accept. And what are they? They're genocide, they're crimes against humanity, there's torture, there's hostage taking, there's mass rape as a weapon of war. Okay. I think I said torture. Okay, so these are called use Kogan violations, and therefore I wanted to tee up that one, and not the only, but one of the reasons why we think that UNRWA doesn't have immunity was under international and not American law. Okay, so here you can see a synopsis, chick-chock of, and anyone who wants to get the pleadings will be happy to send you to them, and I'll explain a little bit more what they are so far. we're in the midst of a fight on immunity with the government, with the United States government, actually. But so here, this is how we shaped the complaint, and we sued these defendants. There's 7 individuals, and the UNRWA itself, 8 defendants. And we allege that they aided and abetted genocide, crimes against humanity, weaponization of mass rape and sexual abuse, and torture. Okay, that's their claim. And it's based on that Hamas was provided safe harbor in UNRWA facilities for weapon storage, command and control operations, planning and staging, and for the genocidal attacks. And we have extensive research being able to prove each one of these points. And that despite knowing of Hamas's use of UNRWA's premises, they consistently took the position against the Israeli government that UNRWA facilities, schools, clinics, and so on were inviolate in their headquarters, and therefore prevented the Israeli army from entering those premises and dismantling their uses for terrorism. That they also ran an educational system that was designed by Hamas, including Hamas, to indoctrinate children and turn into a death cult ideology of genocide and hatred. That they had staff on payroll that even participated in the attacks and were some senior members of Hamas, and used UNRWA facilities for planning and command. And then we came across, unbelievably, that every month since 2018, and actually since 2010, but we pled 2018, UNRWA transferred to Gaza through Israeli territory $20 million in cash, actually with the Israeli government's consent, okay? And the reason that they needed $20 million in US cash every month was, unlike how they pay salaries in the West Bank, in Syria, and Lebanon, in Jordan, where they also run facilities, where they just do direct deposits into bank accounts in local currency, dinar in let's say Jordanian dinar or Lebanese dinar, in Israeli shekel in the West Bank. Here, they transferred in cash, which the people, they have 13,000 employees in Gaza, plus all their suppliers. You can't use cash like that, especially $100 bills. They're supposed to use cash in Gaza. There's no way. You have to go to a money exchanger. Money exchangers were all either part of Hamas or anyway supervised and taxed by Hamas. So what happened is that, and the money changers charge between 15 and 25% to do the exchange. So right off the top, somewhere between 15 and 25% of everyone's salaries went right back to the Hamas money changers by forcing them to take US dollars in cash. And secondly, this cash, I mean, it's a bit over these years, you're talking about $1.3 billion in cash. It's not sitting around on shelves in Gaza, in fact, but it's not used in there's no way to use it other than for criminal facilities. In other words, you can't go buy cement or spaghetti or something in an international contract with cash. That can only be done by bank transfers. And bank transfers, they have plenty of access to bank transfers from Qatar funding and Iran funding and other cryptocurrencies and so on. What they needed, the US dollars and cash, was to pay the smugglers for the weapons and so on. So that's one of our allegations pled. And this plays really well under ATA claim also for Americans, which are going to claim. Before we filed the case, we met with the New York Times and they embargoed. We gave them our materials. They didn't believe that. What do you mean $1.3 billion? Why hasn't anyone ever heard of it? And it was hiding in open source. And that's what we found. That's what our research team found. And New York Times checked all of our sources. We gave them our sources to verify all the different things, including this cash. And sure enough, 1 minute after we filed the case, New York Times came out with its article about the case and about the cash, that they verified it. None of these allegations have been contradicted or denied or even tried to be explained away by the United Nations since we filed it, except for on the issue of the cash. In one of the press conferences, their press said, no, our employees prefer to be paid in cash, right? And have 20% of their salary go to Hamas. This is insane. And next slide. Okay. So the United States government then intervened in the case after we filed it, and they claimed that at the request of the United Nations, in accordance with United States treaty obligations to respect the immunities, that the court lacks subject matter jurisdiction to even hear the case. So the United Nations has not responded, but the Department of Justice has intervened. That was in July. Next slide. So we provided a memo of law in objecting to their thing, and basically, and we'll be happy to provide all this documentation. It's of course in public record if anyone wants, or you can pick it up in Pacer in our case. So basically, we had three different three objections to why. Number one, we said we didn't sue the UN. We sued UNRWA, which on the UN's website is listed as not as a subsidiary organ of the United Nations, but as a quote other entity. And in fact, in all of the resolutions creating UNRWA, never once does it state that they're what's called a subsidiary organ. The DOJ said no, they are a subsidiary organ automatically, and they're also an integral part of the United Nations. Therefore, the treaty which gives immunity to the UN itself gives immunity to UNRWA, which we're contesting, and it's before the judge. Okay. And then we said, even if UNRWA had immunity under the CPI-UN, that's the General Privileges and Immunity Treaty for the UN, it still would not apply to any Hughes-Kogan violations, as I've explained that a little earlier. And third, the individual defendants clearly would not have immunity. If they have any immunity, it would only be for official acts, similar to the way the Supreme Court ruled, I think, on Trump's immunity. Anyway, I'm finishing right now, and so interestingly enough, after we filed this memo, the Department of Justice changed its position and said that they take no position on the 5 individual defendants having immunity or not, only that UNRWA itself and the current Director General and Deputy. So the court has now ordered these individual defendants to appear. So that's it. I've finished this thing. I don't know if we have time, or maybe I've spoken too long. Sorry.
No, I think we do want questions. People are still here and still engaged as long as you have time to go. So yeah. Adora was going to ask questions.
Okay, so reading from the questions in the slide for the chat here. Have terrorists or other terrorist charitable organizations tried to use U.S. courts to collect money or inhibit Jewish organizations?
Yes, but they've not been successful.
And what about American civilians who were killed or injured on October 7th? I believe you've answered that, but if you could just articulate again the difference between the statutes.
We represent close to 200 American citizens, and we're preparing as we speak to file a second case against the same defendants under the Anti-Terrorism Act. Remember that the Alien Tort Claims Act is only for aliens, but the Alien Tort Claims Act, the Supreme Court said, is that the law of that act is not American law, but international law, because it's a violation of the laws of nations. And since I wanted to attack the ability of immunity under international law of Hughes-Kogan violations rather than the Anti-Terrorism Act, which is an American law, then my opinion is that we'd have a much more difficult time beating immunity under the ATA, because America can grant immunity to its own laws, but it can't grant immunity under Hughes-Kogan violations, according to our reading of international law. Once we've engaged now in the issue of immunity, we want to bring, on behalf of the American victims, a second claim, because if the non-Americans are the immunity, which already it's been established for the 5 individuals, so now we're fighting on the organization. once we've got teeth and we've got a hold on immunity there, then we bring in American citizens also, so that if one group's going to have immunity, then they both would end up having it. Because in the end, it's still a use Cogan's violation.
And then I believe the final question is, what about families of IDF soldiers who were US citizens who were killed in the fighting of Hamas?
So as I explained under the Anti-Terrorism Act, okay, where we said that any American soldier, applied to any Israeli soldier who was killed by a terrorist organization, it cannot be considered an act of war. It's considered an act of international terrorism, and therefore they have the same rights as a civilian. And in fact, we represent numerous soldiers and members of the police and defense forces, mostly Israelis, I guess. I don't know if we have any that are dual nationals, but we would bring the same claim because we have other, besides UNRWA, we're looking at some crypto banks and others that we're going to be bringing also anti-terrorism claims and claims in Israeli courts also under, just aiding and abetting terrorism. So yeah, the Americans who are also soldiers who also are killed or injured, we would be happy to represent them, and we would, or you can represent them, and those claims should be brought and could be brought.
And I think there's finally one more question that was added. Are there actions against terrorist organizations or other supporting organizations for demonstrations on college campuses by pro-Palestinian students or outsiders?
Sure. We're not involved in those because we specialize only in counterterrorism cases or crimes against humanity. But there have been cases under other laws that we don't have any specialized knowledge of, but other hate crime laws or other laws against universities that need to protect the students against discrimination or other things like that. So there are currently cases like that pending, but we're not involved in it and we don't really know too much about it.
Wonderful. I think those are all of our questions in the chat. It's been a pleasure meeting with everyone.
And I'd like to thank you for putting on this very, very important topical and presentation that I think that everyone walking away with a better feeling of what's going on and how these problems are being addressed and that they are being addressed. So thank you very much. I want to ask our participants to stay on to complete this poll.
Thank you. And while you're completing the poll, I just want to remind everyone, especially for those who may have joined who are not members of Decalogue, that one of the member benefits of Decalogue is you can fulfill your entire CLE reporting through Decalogue for those of you who are attorneys. So I would highly recommend that you join, even the specialized ones for professional credit that has to do with substance abuse, diversity, etc. You can fulfill your entire reporting through us. So we have a robust CLE program. So please make sure to check out those programs and events. We also do have our Hanukkah party coming up that is family friendly.
Excuse me, Helen, but I need to tell everybody that we lost the
I saw that, Debbie. I want to say that the co-host can't touch the poll that turns it off. So I think that's what happened here. I'm going to relaunch it.
Thank you.
Okay. And so, as I was saying before, we do have a number of programs coming up between CLEs and general programs. And as you know, next year, in the beginning of the year, we will have our judicial reception and other events. So please check our website for upcoming program. And especially if you need CLE credits, make sure to look and to sign up. And if you're not a member, to please join Decalogue and support the work that we do in addition to our various committees, including our committee on anti-Semitism and the Women's Committee, who specifically put on this program in particular. And I do want to thank the other women's committees, the chair and whatnot. And I see there are plenty of individuals on the Women's Committee who are also participating in the CLE today. So thank you everyone again for your participation, and especially Gavi and Adora. Nice seeing you again, Adora, after all these years. Adora and I were in the same law school class together at Chicago, Kent.
Thank you, Helen.